Hello and welcome to the Minimum Competence episode for Wednesday, February 26, 2025. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, we cover Trump targeting Covington and Burling, the Supreme Court ordering a new trial for Richard Glossip, a judge blocking Trump's federal funding freeze, and my column on Washington state taxing data like natural resources. Let's remember, texts are not meant to be believed, but to be subjected to inquiry. And read today's legal news. On this day in legal history, February 26, 1919, President Woodrow Wilson signed the Grand Canyon National Park Act, officially designating the Grand Canyon as a national park. This landmark decision aimed to preserve the canyon's breathtaking landscapes, unique geological formations, and rich biodiversity for future generations. Prior to its national park status, the Grand Canyon had been federally protected reserve, but conservationists pushed for stronger protections. The designation marked a significant victory for the early environmental movement, ensuring that the canyon would be safeguarded from mining, logging, and other commercial exploitation. The Grand Canyon, carved over millions of years by the Colorado River, is one of the world's most iconic natural wonders. Its layered rock formations offer a window into Earth's geological history, dating back nearly 2 billion years. Beyond its scientific significance, the canyon holds deep cultural importance for indigenous tribes, including the Havasupai, Hopi, and Navajo, who have lived in and around the area for centuries. The national park designation helped protect these cultural and historical sites, though it also led to conflicts over land rights. The creation of Grand Canyon National Park was part of a broader movement in the early 20th century to protect America's natural landscapes. This movement, championed by figures like President Theodore Roosevelt, laid the foundation for the modern national park system. Today, Grand Canyon National Park attracts millions of visitors annually, serving as a testament to the enduring importance of conservation efforts. President Donald Trump has ordered the suspension of security clearances and government contracts for the law firm Covington and Burling due to its legal assistance to special counsel Jack Smith. In a memo signed in the Oval Office, Trump accused law firms of using pro bono work to obstruct the government. The directive specifically targets Peter Koski, a Covington partner, and calls for a review of the firm's federal contracts. Smith recently disclosed that Covington provided him with $140,000 in pro bono legal services as he faces government scrutiny. Covington stated that it represents Smith in a personal capacity and will continue to defend his interests. Legal experts note that security clearances are crucial for private attorneys handling national security matters. Trump, who has been indicted in 2 cases led by Smith, referred to the order as the deranged Jack Smith signing and mocked the prosecutor after signing the memo. The U.S. Supreme Court has ordered a new trial for Oklahoma death row inmate Richard Glossip, ruling that prosecutorial misconduct violated his constitutional rights. In a rare win for a capital defendant, 2 conservative justices joined the court's 3 liberals to overturn Glossip's conviction. Oklahoma's Republican Attorney General had also acknowledged errors in the case, including prosecutors withholding evidence and failing to correct false testimony. Glossip was convicted for allegedly orchestrating the 1997 murder of his boss, Barry Van Treese, though the actual killer, Justin Sneed, was the state's key witness. Newly disclosed documents revealed that Sneed had considered recanting, was coached by prosecutors, and lied about his mental health history. Writing for the majority, Justice Sonia Sotomayor stated that correcting Sneed's false testimony would have significantly damaged his credibility. Chief Justice John Roberts and Justice Brett Kavanaugh joined the liberal justices in the ruling, while Justice Amy Coney Barrett partially agreed but wanted the state court to decide if a new trial was warranted. Justices Clarence Thomas and Samuel Alito dissented, arguing the case should have been left to Oklahoma courts. Glossip's execution had been blocked 9 times before, and his attorney emphasized the ruling as a crucial step toward justice. It remains uncertain whether Oklahoma will retry the case or pursue the death penalty again. A U.S. judge has extended an order blocking President Donald Trump's administration from enforcing a sweeping freeze on federal funding, citing concerns that the policy could be reinstated. U.S. District Judge Lauren Ali Khan ruled that despite the administration's withdrawal of an initial memo pausing grants and loans, statements from White House officials suggested the freeze was still in effect. The funding pause, announced in January, aimed to review federal financial assistance programs for compliance with Trump's executive orders, including those ending diversity initiatives and pausing climate-related projects. Nonprofits and small business groups sued, arguing the freeze would cause widespread harm. Ali Khan criticized the policy as legally baseless and impractical, saying it would either halt up to $3 trillion in spending overnight or force agencies to review all grants within a day. She called the administration's actions irrational and warned of a potential national crisis. The ruling prevents the government from reimposing the freeze under a different name, marking a legal setback for Trump's efforts to reshape federal spending priorities. And in my weekly Bloomberg tax column, I examine Washington state's new data broker tax, a well-intended but ultimately insufficient approach to curbing exploitative data practices. The legislation treats consumer data like a natural resource, imposing a severance tax on its collection. However, this framework fails to address the real issue, long-term data retention and reuse. A more effective solution would be a retention tax, which would discourage firms from hoarding personal data indefinitely. Under the current bill, companies pay a tiered tax based on the number of residents whose data they collect. While this sounds like a fair approach, it risks consolidating data power in the hands of large platforms that can absorb the tax and continue selling consumer information without restriction. Worse, the tax may encourage firms to store data longer, giving it an artificial market value that promotes hoarding rather than limiting collection. Unlike oil or minerals, personal data is not depleted upon use. It can be endlessly repackaged and resold. A retention tax would align economic incentives with privacy concerns, forcing firms to justify prolonged data storage and pay accordingly. Without it, Washington's proposal does little to curb long-term privacy risks and may ultimately entrench the very data exploitation it seeks to prevent. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment and can leave a rating or review on your podcast player, we'd sure appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, to survive, you must tell stories.